Lawyers of Reddit. What's the most ridiculous argument you've heard in court? As a corporate lawyer, the most ridiculous argument I come across almost monthly is as follows. Fortune 500 company signs a garbage contract and is going to lose a lot of money due to the plain language of that contract. Fortune 500 company argues unconscionability, specifically that said company was not sophisticated enough to read the contract and no reasonable person would ever agree to the term or terms in dispute. In sum, multi-billion-dollar firms claiming they're incapable of reading contracts. Law student. Former professor's story defendant busted for possession of narcotics. They were in the pocket of his leather jacket. He argues the search was illegal because with his buttery smooth leather jacket, there's no way the officer would have felt the drugs in his pocket during a pat-down. So he shouldn't have reached in the pocket to find the drugs in the first place. Judge asks if the jacket is the one he was currently wearing in court. It was. Judge asks to feel this jacket in the pockets. Defendant hands it to the bailiff. Judge finds more drugs in the pocket. Needless to say, it didn't go well for him. I was a juror, but this was a hell of a defense. Defendant ran through a red light and crossed against traffic in front of an officer. She was over twice the limit. It wasn't her fault. She had a cut on her arm that her dog licked. The yeast from the dog's saliva entered her bloodstream and converted her blood sugar into alcohol. An opposing attorney the other day said I should not cross-examine his witness at a preliminary hearing because it would only hone the witness's testifying skills to be cross-examined at trial. I laughed out loud. Oh geez, where do I start? I mean, I could tell plenty of these about my own clients, but I like this one. A lady has an injury/comp case. It's for her upper back and of course complex regional pain syndrome. She decides she needs the insurance company to pay for a special mattress for her, like a $6,000 memory foam, with heat and massage and 1,000 other features. And not just a twin. She needs a California king because of course her layabout unemployed boyfriend needs to sleep there too. We spend months litigating this damn thing. Finally, she buys it herself and my client agrees to give her $1,500 just to be done with it. The judge takes myself and opposing counsel aside and says he's gonna motherfuck us if we ever say the word mattress in his court again after wasting all this time. It was that ridiculous. Not 3 months go by and the case comes on for another hearing. After exhausting all the chiropractic care allowed under the law, her doctor was seeking a variance to get some additional chiropractic. We get to court and I'm arguing it should be denied, etc. Judge turns to her and says, "Ma'am, why do you feel you need more chiropractic care?" She pauses for a minute then says, "I'm having a lot of trouble sleeping on my mattress. I think I saw smoke coming out of his ears." In family court hearing a motion for entry of a restraining order for an abusive husband. Husband's lawyer argues that in a marriage, there is implied consent for a certain amount of abuse/violence. I have a brief encounter, personal injury prospect. Old lady slipped and fell on an icy driveway which was not salted or maintained, so she wanted to sue for damages. After hearing the story, turns out the lady fell on her own driveway which she did not salt, maintain. She was wanting to sue herself. Had a pro se litigant argue that she didn't know the credit card company because Jesus. The basic argument was that debt is a sin, or maybe not paying the debt was a sin. And Jesus died for all of our sins. Therefore Jesus died to pay off her debt. Brilliant. I was in the public gallery for this while studying law. I was not the lawyer. Leeds Crown Court back in the early 90s. 75 yo foreign, yes. This is important. Man was facing a preliminary hearing relating to charges that he had sexually touched a 13-year-old relative. His barrister made a successful plea for bail based upon this man being an established pillar of the immigrant community. And the judge asked the old man if he had anything to say before he was bailed until the next hearing in a month. He made 2 comments: 1, she was wearing very tight shorts and I should not be held responsible because no real man could resist something like that. The judge reminded this was a preliminary hearing not a trial, so he should wait until the trial to argue his case, especially statements that are far from exculpatory and are better suited to mitigation. 2, I cannot reappear in a month because I am flying back to my home country tomorrow and will not be coming back. The barrister appeared to be just as surprised as the rest of us. The judge ordered the defendant's passport seized and he was remanded in custody until his trial. I heard this story from a cop. A man was arrested for charges of assault and rape. This was in Oklahoma and I'm in Texas, so I'm not sure what the offense is called there. Anyway, he was being accused of shoving the woman on the ground where there was some debris and she sustained injuries, hence the assault, and then accused of violently raping her. During court, the injuries were mentioned. The man, representing himself, objects. Allegedly, his exact words were, "So, how do you know that the injuries were from when I pushed her down, and not from when I raped her?" From what I heard, the judge's face was priceless. Several years ago I was doing a civil trial, personal injury, defending a woman who, allegedly, hit a bus matron with her car. We had offered to concede liability and just try damages. In other words, the jury wouldn't hear the circumstances of how the injury happened. Just that we agreed my client caused the injury, and they would only decide the amount of damages, We had evidence that the plaintiff was significantly exaggerating her injuries. The plaintiff's attorney refused to agree to our concession, thinking that if the jury heard the circumstances they'd want to give even more money to punish my client. So we went to trial on liability. The plaintiff called one witness, her client, who testified that an older woman in a green car hit her. They rested and I moved for a dismissal for failure to prove a case. There was literally no evidence connecting my client to this incident. Just an older woman in a green car. The plaintiff never bothered to call my client to the stand. The attorney told the judge that the bus driver had written down my client's license plate and gave it to the police. They never bothered trying to find the bus driver. The attorney asked if she could just put the police report in and I objected that it was hearsay. The attorney then actually said, please just let me put this in. I haven't had work in a while and I got retained by a firm to try this case. I really need to win this. Of course I didn't agree. And the judge dismissed the case. I felt a little bad for her, but that was maybe the worst presentation of a case I ever saw. I spoke with the jury afterwards and they all said they hated the plaintiff, didn't believe a word she said, and likely would have found in my favor anyway. Moral of the story: be prepared in court. Not a lawyer, but I was in traffic court and a cab driver had got a ticket for running a red. He argued that it was really difficult to see because the sun was rising, morning, right where the light was. He was traveling west. Lawyer here. During an order of protection hearing, the 6 feet 3 inches muscular tattooed idiot told the judge that my 5 feet 1 inch female client deserved the black eye he gave her because she wouldn't stop running her mouth. He actually expected the judge to be sympathetic or something. The second he admitted to hitting her, the judge cut him off and said order of protection granted. Next case. Not in court but a conversation in my office. It doesn't matter if you were sober or not. You jumped out of a 3rd-story window with a beer bottle and threw it at a cop. The jury is going to think you were drunk. Also, I think you were drunk. Edit, actual lawyer here. Hands down the most ridiculous argument I've ever heard was a constitutionalist. Pro se defendant trying to explain why the court lacked jurisdiction over him. I was prepared for the standard arguments about freemen on the land, non-corporate natural person, admiralty court, etc. But this one was different. This particular defendant was part of a Jehovah's Witness compound and happened to be Marshallese American, i.e., he was black. After the court patiently explained to him that it has jurisdiction over all persons in the county, the defendant promptly piped up that, under the Dred Scott decision, he wasn't a person and the court had no jurisdiction. Prosecutor here had a case where a man raped his 6-year-old daughter because she wore suggestive clothing and seemed to be asking for it. He tried to argue that, girls are just sexually active at a younger age now. I remember thinking, what would Dexter do ? Anyway. Man got convicted and is now serving 2 life sentences plus 100 years. Edit, the reason for that sentence is that he will not be eligible for parole. He was convicted of 2 counts of rape, 2 counts of incest, and 2 counts of aggravated child molestation. In my jurisdiction you're eligible for parole on a life sentence after 30 years. Life and life without parole are 2 different sentences. Here, he was not eligible for life without parole. So in theory at least, yes, he could serve 2 consecutive life sentences, which would be 60 years, and then parole. Now, however, we are certain he never draws another breath as a free man. I've done several of these cases, and to me, they're much harder than murder cases because of the pressure. In this case, the man had no other complaints than this as a father. So if I lost, the poor girl goes back to rapist dad. Not so much ridiculous as ghastly, but a man accused of raping his own daughter saying he couldn't have done so because he had a 9-inch cock, and it would have caused her damage, and that the physical signs of sexual activity that she did exhibit were because she'd been screwing the family dog. I don't do criminal law anymore. That was enough for me. Edit, lots of people asking what happened. Should probably have put that in here originally. I'd left the firm by the time it actually got to trial, but was kept in the loop about the case by friends still there. He was found guilty and went off to prison. Former correctional officer here. I once sat in on a much similar case where a man was accused of having sex with his teenage daughter. The defendant's main defense was that the daughter was lying to get him in trouble, and he could prove she was lying because he had a very distinct tattoo on his penis, and she couldn't describe it. The daughter was on the stand testifying and the defense attorney started down that line of questioning and the daughter flat out said, no, I can't describe it, because I never saw it, because every time he had his dick out he was putting it inside of me. Jury took about 10 minutes to convict. Edit, to clear things up a bit. This line was not the only one used to convict. There were other witness statements and reports that were used. Former assistant state attorney/prosecutor here. This defendant is called up for arraignment and the judge is telling him that he's been charged with theft for stealing a roll of scratch-off tickets from a gas station. The judge informs the defendant that since the value of the tickets was over $300, therefore it's a felony rather than a misdemeanor. The defendant says to the judge, but Your Honor, to be fair, the tickets were all losers, implying it's not theft at all. I was amazed at the ingeniousness yet futility of the argument. Traffic court, speeding ticket. Your Honor, I didn't speed, and I can prove it with logic. Judge, okay. Lady, drive a Prius. Judge. Question mark lady, that proves I'm responsible. Specifically in the realm of cars. So I obviously wouldn't speed. She had to pay the ticket. I have a story for this one. I'm not a lawyer nor could I talk at the time. During a custody battle between my grandparents and my mom and dad who were addicts, the judge asks why my parents should have custody. Well, we are his parents. The judge says, well, you guys have substance abuse issues. No, we don't. So you're not using anything? No, we're both clean. When is the last time you've used? A few days ago, and we're done now. Me grandparents won that day in court. This story has been told to me a few times by my grandfather, actual lawyer. What I dub the surprise party defense in a hearing for an order of protection in which ex-wife is trying to get an order of protection against ex-husband who had been stalking her. They have a high school-aged child together. Ex-husband tries to argue against the order of protection by saying they may need to be able to communicate about the child. The judge points out that they can communicate through the child, and also that other family members have been put in place by the juvenile court to be intermediaries, re-pickup, drop-off, etc. Then ex-husband has a brilliant lightbulb idea. Judge, what if I need to throw my son a surprise party, and I need to keep it secret from everyone, but his mom still needs to know so she doesn't throw a party the same day? In other words, while I admit I've been stalking my ex-wife and that there are grounds to grant an order of protection, you should not grant that order just in case I need to throw a surprise party one day. What made it was how clever he thought the argument was. Thus was born the surprise party defense. Edit, a lot of you are upset about the comment of communicating through the child. That was probably a poor way to phrase it. In this situation, the father would be barred from passing messages to the mother through the child. He can't say, tell your mom X, but, of course, some indirect communication is going to occur. And that is what the judge was referring to. In other words, the father cannot argue that he needs to be able to have direct communication with the mother for purposes of coordinating childcare. Things like that, which is often the issue, because the child in this case is old enough to tell both parents, for example, about school, friends, trips, grades, etc. It is not as if the judge ordered the child to be the intermediary. That is ridiculous. Also, I sort of simplified the complexities of it because these people's parental arrangement was not the point. The dumbness of the argument was the point. But this is a criminal judge determining an order of protection. There is a whole separate juvenile/family court judge that actually determines the custody arrangement and things of that nature. The bottom line is, the guy was trying to use the kid as an excuse to avoid an order of protection so he could continue to stalk and harass his ex-wife.